Hello, I'm Hishay and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. Before we begin, here's the headlines. Hearing a plea challenging former Mehbooba Mufti detention, Supreme Court asked Centre how long will detention continue. Centre to reply. In Jheeram Ghati Naxal Attack case, Supreme Court dismisses Chhattisgarh government plea seeking examination of additional witnesses. Delhi High Court allows early hearing plea by CBI ED in 2G appeal case to be taken up on daily basis from October 5th. Delhi High Court directs Centre to file a report in Rakul Preet Singh plea seeking interim direction restraining media from reporting on her NCB investigation.
India Legal presents Courts Roundup.
The Supreme Court has placed a pointed question before the Centre through its counsel, Solicitor General Tushar Mehta, on what is the maximum period for which a person can be detained and whether the Centre proposes to continue detention. The hearing was about Mehbooba Mufti, who served as the last Chief Minister of Jammu and Kashmir Autonomous State, and the issue of her indefinite detention. The court decided to take it up on October 15 after the Centre asked for time. The District Magistrate Srinagar, who passed the order for preventive detention of former Jammu and Kashmir Chief Minister Mehbooba Mufti under the Public Safety Act, has told the Supreme Court that the order was passed after subjective satisfaction of the detaining authority that is necessary to detain Mufti so as to prevent her from acting in any manner prejudicial to the maintenance of public order. Arguing for Mufti, for her counsel, Advocate Nitya Ramakrishnan, said that Mufti has not been allowed to meet her family. At that, Justice Sanjay Krishna Kaul asked how that would be possible considering she is in detention. He granted time to the Union of India to file a reply to the amendment plea within a week. The judge also asked the Solicitor General how long the detention would be and what was the order against her. The Centre has responded on the 2 points of how long the detention of the person can be and whether the Centre wishes to extend this. The Solicitor General told the court that the Centre has already filed a response to that but wants time to file its response on the amended petition. The habeas corpus plea was filed by her daughter Iltija challenging detention of Mufti under PSA. The Supreme Court today has dismissed a plea filed by Chhattisgarh government seeking examination of additional witnesses in the Jheeram Ghati Naxal Attack case 2013. The state government had earlier approached the Chattisgarh High Court seeking a direction to the Judicial Commission set up to probe the 2013 attack to examine the additional witnesses in the case. However, the High Court had dismissed the same, prompting that the state to approach the Supreme Court. The bench of Justices Ashok Bhushan, R. Subhash Reddy and M. R. Shah has now dismissed the appeal against the order of High Court. Justice Bhushan categorically stated that the Judicial Commission had made it clear that it would not accept more witnesses' statement after October 2019. Senior Advocate Abhishek Manu Singhvi, appearing for the Chhattisgarh government, insisted that the Commission can examine 5 more witnesses. The court noted that when the Commission invited those who wanted to be examined to file affidavits, no one did so. While dismissing the appeal, the court observed you wanted the expert witness to be examined, but Commission did not agree. You may have extended the Commission's tenure, but it has closed the proceeding. On May 25, 2013, Naxals had attacked a convoy of Congress leader in Jheeram Valley located in the state's Bastar district. 29 people were killed in the attack, including then State Congress Chief Nand Kumar Patel, former leader of opposition Mahendra Kumar, and former Union Minister Vidyacharan Shukla. While noting that as per Section 90 of the Indian Penal Code, consent obtained under misrepresentation of facts is illegal, the Supreme Court has ruled that such misinterpretation has to be in proximity to the occurrence of the incident and not stretched over a period of 4 years. To put the facts simply, the case before the three-judge bench of Justice Rohinto, Fali Nariman, Navin Sinha and Indra Banerjee was that a man from the scheduled tribe community was in a relationship with a Christian girl. The couple were in a relationship for years, after which the boy was set to marry another woman. A week before the marriage, the woman had lodged a complaint alleging that she was raped by the appellant on the false promise of marriage. A tribal court in Ranchi convicted the man, after which the order was appealed in the High Court. After the conviction was upheld by the High Court, the appellant approached the Supreme Court. The bench then proceeded to deal with the main question whether the prosecutrix consented to the physical relationship under any misconception of fact with regard to the promise of marriage by the appellant. Elucidating on the point of law, the court noted, but the misconception of fact has to be in proximity of time to the occurrence and cannot be spread over a period of 4 years. It hardly needs any elaboration that the consent by the appellant was a conscious and informed choice made by her after due deliberation. It being spread over a long period of time coupled with a conscious positive action not to protest. The conviction of the appellant was found to be unsustainable and was thus set aside. We are now joined by Shivam. Shivam, please update us on today's proceedings.
Court noted that under Section 90 of IPC, the misconception of fact has to be in proximity of time to the assurance and cannot be spread over a period of 4 years. It hardly needs any elaboration that the consent of the appellant was a conscious and informed choice made by her after due deliberation. It being spread over a long period of time coupled with a constant positive action not to protest. The court in this matter further said that the age of the victim on the date of occurrence, the possibility of her being above the age of 18 years on the date of cannot be ruled out. Therefore, the benefit of doubt should be given to the appellant. The court view is it. The court has allowed the appeal of the accused and in condition was set aside. Yes.
Thank you for the update. The Delhi High Court has allowed the early hearing application moved by Central Bureau of Investigation and Enforcement Directorate in appeals against acquittal of all accused. The leave to appeal will be heard on the day-to-day basis from October 5th, said the court. Order was pronounced by single-judge bench of Justice Brijesh Sethi. CBI and ED had sought an urgent virtual hearing in the matter to facilitate a decision in their leave to appeal before the retirement of Justice Sethi in the end of November 2020. Appearing for the agency's ASG Sanjay Jain had contended that the scheduled date of the October 12 should be advanced in the public interest and to save judicial time. All acquittal accused persons, including A. Raja and K. Kanimoji, had opposed the early hearing plea on the ground that since the High Court has taken up only those pending criminal matters in which the accused was still in custody, there was no urgency in the present case. Retirement of a judge was not a legal ground to advance an already fixed date, counsel claimed. The Delhi High Court sought reports from Central Government News Broadcaster Association and other authorities on the statute of representation by actor Rakul Preet unsubstantiated media reports on her in relation to the investigation by Narcotics Control Bureau. The single bench of Justice Navin Chawla has further directed the Ministry of Information and Broadcasting Union of India and other regulatory authorities to submit a status report stating steps taken by them in pursuance of court's last order. The actress has stated that the slender campaign being run by the media against her has done irreparable damage to her and her family, has largely invaded her right to privacy, and has even affected her commercial interest adversely. She has alleged that despite the High Court order urging the media to exercise restraint in their report in this case, the news channel continues to air fake news that malign and defame her. In the backdrop of this allegation, Rakul Preet has submitted it is settled law that the media, even otherwise, ought not to act in a manner that is likely to hamper or interfere with a criminal investigation or cause undue publicity to the witness in such investigation. The petitioner is entitled to a restraint order against the respondent to ensure that the offending programs and write-ups are not broadcasted, published or print or circulated, since the same may result in interference with the administration of justice and would be against the principle of fair trial or open justice. The Supreme Court has directed the state government to ensure that dry ration is provided to sex workers without insisting on identification proof. The bench of Justice L. Nageshwar Rao and Ajay Rastogi has directed that sex workers who are identified by the National Aid Control Organization and state committees be given this benefit. The state government has been asked to apprise the court in 4 weeks about the implementation of this order and the number of sex workers who have benefited from the same. While passing its order, the court noted that it is glad that none of the states or the centre has taken an advisory stand. The court was hearing an application filed by NGO Darbar Mahila Samanvay Committee, which had moved the court to highlight the destitute faced by sex workers on the account of COVID-19. The application seeks relief measures for over 9 lakh female and transgender sex workers across the country. The court said, "We are at this point concerned with points raised in this application. We are concerned that sex workers can't access dry ration, cash transfers and other facilities due to lack of identity proof." Additional Solicitor General R.S. Suri submitted that in principle the centre does not have objection if state provides amenities without insisting for identity proof. Council for Maharashtra, Karnataka and West Bengal submitted that they have already initiated steps to provide dry ration without insisting on voter ID card. The Karnataka High Court on Monday dismissed a petition seeking the transfer of the sandalwood drug scandal case involving Kannada actresses Ragini Devidi, Sanjana Galrani and others to the National Investigation Agency. During the hearing, the bench of Chief Justice Abhay Srinivas Oka and Justice Ashok S. Kinagi went through the FIR that was registered against the 2 prominent Kannada actresses and others at the Cotton Pet police station on September 4. The court observed that the FIR was registered very recently and therefore it cannot be concluded that the investigation is not being carried out properly. Initially, the petition filed by Geeta Mishra through advocate G.R. Mohan sought for the transfer of the sandalwood drug case to a special investigation team. However, during the course of the hearing, Mohan pushed for transferring the case to the NIA. The court had declined to appoint an SIT to probe the case. The petitioner also stated that she had given a representation to the Additional Chief Secretary of the Home Department, citing various instances on road accidents involving people with high society who were under the influence of drugs. Responding to this, the court opined several incidents from the year 2017 and 2019 have been relied on it in the petition. It has not been stated whether in relation to all cases whether FIR was registered or whether investigation is complete or not. On the basis of such representation, a writ of a mandamus cannot be issued. The petition will have to be very specific about specific cases where proper investigation was not carried out. The Bombay High Court has affirmed the award of 5 crore rupees compensation payable to a party who had not been handed over the possession of certain property even after a delay over around 80 months. The order was passed by Justice S.C. Gupte, who dismissed a second appeal in the matter filed by Renaissance Infrastructure Limited. The promoters the dispute arose after Renaissance filed to give a possession of the premises in 2010 as agreed by them in an agreement for sale between Renaissance and the purchaser. The RERA authority calculated the compensation as per the clauses in the agreement as amounting to 5.04 crore rupees. Ruling in favor of purchasers, the RERA authority ordered Renaissance to pay 6.3 lakh rupees per month and to hand over possession of the property to the purchaser. Renaissance challenged this order before the appellate tribunal. The appellate tribunal asked Renaissance to deposit 50% of the compensation amount as per section 43(5) of the RERA Act for entertaining the appeal. However, when Renaissance failed to pay the pre-deposit, the appellate tribunal dismissed the appeal. Therefore, Renaissance filed a second appeal in the Bombay High Court. Therefore, the High Court dismissed the second appeal and order as follows. The appellant is given 4 weeks' time to pay the amount ordered by the adjudicating authority, RERA. If the amount is not paid within 4 weeks, the tehsildar may proceed with a sale of attached property. Dani applied for a stay on this order. However, it was rejected by the court. A special NIA court at Ernakulam has convicted ISI terrorist Subhahani Haja Mohideen and sentenced him to life imprisonment in connection with the ISI Omar Al-Hindi module case. Mohideen, a 35-year-old resident of Tirunelveli district in Tamil Nadu, was arrested by the NIA in October 2016, subsequent to seizure of incriminating materials from his residence, including materials indicating his links with the proscribed terrorist organization ISI. Special Judge P. Krishna Kumar sentenced him to a life imprisonment and imposed a fine of 2,10,000 rupees for the following offences. The court has largely relied on the testimony of J.S. Mohammed Kamal, co-accused turned approver in this case. Allegedly, Mohideen had confessed to Kamal that he had migrated to join ISI and was fighting for it in the battlefield of Mosul. The court acknowledged that an extrajudicial confession made to an approver are ordinarily a weakest piece of evidence. However, it held that the same may be relied upon if there are undeniable corroborative evidence of a sterling quality. In the case of at hand, the court noted that none of the aspects brought out in the cross-examination of the approver was capable of challenging the intrinsic worth of the evidence. The Punjab and Haryana High Court has restrained schools situated in areas within its jurisdiction from charging transport fees from students. In view of the fact that the students are not going to school, the transport fee may not be charged. The bench of Justice Ranjan Gupta and Karamjit Singh ordered. The division bench was hearing an appeal against a July order of the single judge wherein direction were given in relation to charging fee etc. from the students in COVID-19 situation. The court was informed that the students are being charged transport fees even while the classes are being conducted online. Further, annual fee of 34,000 rupees was being levied for building maintenance, even though the building has not been in use for the last 7 months. In the said case, the single judge had held that all schools, irrespective of whether they offered online classes during the lockdown period or not, are entitled to collect the tuition fee. This was challenged before a division bench headed by Chief Justice Ravi Shankar Jha, who clarified that even though the schools are permitted to collect tuition fee, they shall not strike out the names of such students who have either sought concession, waiver of school fee until disposal of their representation. That appeal is still pending and is scheduled to be taken up on October 1st this year. Inter alia, the court had ordered that annual charges meant for maintenance of the school building shall remain stay to the extent of 50%. This middle ground is taken to ensure that school authorities are able to maintain their premises. The Punjab and Haryana High Court has allowed an anticipatory bail plea moved by a person accused of instigating people to pelt stone at police officers on the condition that he plant 10 trees and tend them for 2 years. The person, a wage earner, was accused by injured policemen of being a part of group that was instigating people to pelt the stones at police. The police were in a locality where people were protesting against those who tried to keep them from leaving their homes, citing the COVID-19 pandemic. Justice Haripal Verma remarked that given the nature of the allegation and since the police are fighting against COVID-19, the bail application may be released on bail on the condition that he will offer his service to plant 10 trees and to maintain these trees for 2 years. The bail applicant had argued that he was not part of the group that instigated the people in the locality. Rather, his counsel averred that the man was filming the entire incident, which displeased the police. He submitted that he had already joined the investigation and was cooperating. This fact was not disputed by the prosecutor. Taking note of this submission, the judge allowed the plea for bail. Advocate Vishal Garg Narwana appeared for the bail application. Applicant and APP Manish Jain represented the state. And that's it for Courts Roundup today. Thank you for tuning in. Keep watching APN for more updates from around the nation.
India Legal presents Courts Roundup.